The British Columbia Court of Appeal justices who had suddenly decided to come to Cranbrook, BC, a tiny city of about 15,000 people at that time, located in the far southeast corner of British Columbia near the Alberta border, to take this lower court judge to lunch. The reason the judge excitedly informed us we had to keep on time in his courtroom that day. We're not there to soak up this judge's great wisdom. These justices are appointed by the Prime Minister of Canada. The lower court judges are appointed by the province. This judge was truly flattered and feeling very important about the attention he thought he had commanded from the top justices in British Columbia. Judges preside over the lower provincial courts, justices preside over the higher courts. I knew why they had come. I was doing things, shall we put it, differently. They had already dropped the charges in another lower court matter in another city where I began the approach. I was not relying on Section 35 of the Constitution Act 1982. I was relying on fundamental international religious freedoms. And learning from the previous encounter, I had enhanced my effort to avoid a repeat response. I had filed a notice of constitutional question to ensure they could not just pick up the ball and run away, or at least so I thought. I assumed fair play. That Cranbrook judge looked very different when he returned from lunch that day. He was no longer cocky with me. Before, he had been taking me on like an old nasty junkyard dog, pulling on his chain, licking his chops, playing with me, he thought, he being the far superior contender about to teach me a painful lesson. Now he would barely risk direct eye contact with me. During the lunch break, one of the BC Court of Appeal justices had found me in the little courthouse law library where I was reading a case in an old law report. He came swooping in to try to see what case I was reading. He was even adjusting his glasses as he tried small talk as he was trying to read the case cite. I wear graduated lenses now too, so now I really get what that was about. I closed the book. So, found something interesting, did you? Not really. I was just killing some time. I followed the feeling to check out the courthouse law library. He then peppered me with questions designed to understand where I was coming from in my defense. Another lower court judge had tried to get me to disclose my client's defense before the Crown had even started its case. No amount of threats and intimidation got me to move. I stood my ground, and when he finally looked like he was about to have a heart attack or seizure, neck veins popping, face all red, he yelled at me, "I cannot make you tell me, can I?" I just kept my eye contact and shook my head in a silent no. It was absolutely nuts what he was asking of me. Of course the answer was no. A lawyer does not even have to proceed with a defense where the Crown has failed to prove its case beyond a reasonable doubt. It is called innocent before proven guilty. After the Crown prosecutor presents the case, the lawyer can move for dismissal. To be ordered to tell the Crown prosecutor how I plan to defend my clients so that the prosecutor can try to shape their case to address mine? Well, no. Rising from his chair, the irate judge pointed his finger at me and yelled, "I will make you personally pay for this, Miss Switlo." Then he stormed out of the courtroom without the usual ceremonial departure, leaving the other lawyers who were needing their matters dealt with at a complete loss as to what to do next. The BC Court of Appeal justice in that Cranbrook courthouse law library, frustrated that he could not acquire the intelligence from me that he was after. His intensity in his voice had been rising, changing course when I shared a few things after he finally went quiet. I reminded him of our duties as officers of the court, spoke about Crown allies and Crown duties, the honor of the Crown, about how offensive behavior of any officer of the court, such as from that Cranbrook judge, threatened the very peace. How my supreme duty was to protect the peace, and how that judge was triggering very serious constitutional and rule of law consequences. He looked at me, offered his hand, and said, "Well, I guess we will just have to keep watching you." Still holding my hand and looking into my eyes, he then added, "And maybe we will need to learn some things." Then he accorded me the respect of a nod, and he left. Samano ended up comforting me that day. I was mortified at the treatment of this elder and longhouse teacher. I had felt responsible because I had put him on the stand. I got their hunting rifles back, which were accidentally banged on the ground and completely disrespected as they were being passed over. This upsets the calibration, and these are very old rifles that have been passed on because of how they are used. And there were no convictions. When the Cranbrook judge, giving us his decision by conference call, failed to address the notice of constitutional question I had filed, had been argued, and I asked about that part of his decision, he said to me, "You have your win." Well, no, I did not. The judge simply ignored the notice of constitutional question. There was no mention of it whatsoever in his decision. He did not even state why, if this was his decision, he did not need to decide the constitutional issues I raised and were argued. "You are not dealing with my notice of constitutional question?" I was shocked. "No," and you could hear a little of that junkyard dog emerge. He slyly said, "And there is nothing you can do about it." Indeed, there was nothing to appeal from because nothing had been decided. It was as if I had never filed it. My only move was to report the behavior of the judge, but there was no point in that.